Good morning, Mr. Chairman and members of the committee. My name is Russell Nobile. I am an election integrity lawyer at Judicial Watch. The core point of my testimony is simple. Public confidence in integrity of elections is declining. The decline is not driven by lack of ballot access, but rather inadequate and lax enforcement of basic election integrity safeguards. The data tells a clear story. Voter registration and turnout continue to go higher, and minority ballot access is at or near record levels. Historical racial disparities supporting the need to promote ballot access have largely been eliminated. At the same time, the public strongly supports common sense election integrity measures. Large majorities support voter ID and uniform election deadlines. They support proof of citizenship requirements and clean registration lists. Yet despite this consensus, many states have moved to undermine election integrity. One of the most troubling shifts has been the expansion of universal mail voting, which sends unsolicited ballots automatically to all voters regardless of eligibility. My written testimony describes how progressive politicians proposed this very system 100 years ago. It was a bad idea then, it remains a bad idea. No mature democracy would adopt such an insecure voting system. Among other ills, it weakens chain of custody protections, it increases the risk of coercion, and brings that risk of coercion to people's houses, a real risk for vulnerable voters. It risks third-party interference and administrative error. It erodes public trust in elections. Universal mail voting is bad policy in any context, but it's particularly bad when combined with inaccurate voter registration lists. Not long ago, the Supreme Court found that 24 million registrations, about 1 in 8 in the United States, are invalid or inaccurate, and 2.75 million people were registered in multiple states. Dirty lists have long been the gateway for other election mischief. Take California, who Judicial Watch is suing right now on behalf of the Libertarian Party. It has both universal mail voting and dirty registration lists. Our own internal analysis found that 21 counties with approximately 6 million voters removed a combined 11 voters over 2 years for change of address. That's 11 voters removed from a group of 6 million, 11 over 2 years. The NVRA imposes modest list maintenance duties on states, and it guarantees organizations like Judicial Watch access to list maintenance records so we can verify compliance with federal law. Many states fail under both federal obligations. Many do not conduct meaningful list maintenance, and when we simply ask them for the records to verify, as we're allowed to under federal law, they refuse, delay, or claim the records do not exist. Now they're not even giving the records to the Department of Justice, where I formerly worked, and would ordinarily ask for these records from 2004 to 2010. Those refusals are not just technical oversights. They defeat transparency, they prevent public oversight, and undermine public confidence in the election administration. Last year, Judicial Watch reported that our enforcement efforts over the years have resulted in more than 5 million ineligible registrations being removed nationwide. 5 million. Despite our success, we've barely moved the needle. Just last month, Oregon's new Secretary of State announced that they needed to remove 800,000 inactive voters in response to our lawsuit. The evidence shows that Oregon hasn't removed voters since 2017. While Oregon's announcement is progress, it illustrates just how pervasive state noncompliance has become. We have other suits pending. Finally, I address the recent trends where states are allowing ballots to arrive days and weeks after Election Day. For the last 5 years, my colleagues and I have sued several states challenging this practice, and last month the Supreme Court ruled in our favor in the first case in which we represent Congressman Michael Boss in his suit against Illinois. It took 4 years to get a federal court to say that we could sue, and finally the Supreme Court agreed. The regressive practice of allowing ballots to roll in for days and weeks after Election Day is chiefly responsible for creating the Banana Republic-style confusion that follow American elections today. Judicial Watch's client, Libertarian Party of Mississippi, along with the RNC, successfully sued Mississippi in 2024 over this same practice. We won, and then yesterday we filed our brief with the Supreme Court to defend our win. The Supreme Court will hear that case on March 23rd. Our brief is attached in the record. 76% of the public support it. History explains why election integrity safeguards exist. They're not adopted by accident, and they're not racist. Thank you for inviting me to testify today. I look forward to your questions.
Mr. Noble, going back to that concept, we heard testimony earlier about the chairman had great questions about the connection between timely election results reporting and voter confidence. I'd like to hear your perspective on that, but also in your written testimony, you go a step further and note that election ballot deadlines past Election Day, in your view, even violate federal law. Tell us about that.
Yeah, it's not just us. The Court of Appeals for the Fifth Circuit said that. So we've been litigating this for 5 years. When Congress enacted the first election integrity provision in the history of Article 2, it enacted Election Day. And in all times, Election Day ended on Election Day. But in the last 15 years, there's been this activist effort to get state legislators to extend ballot receipt deadlines in a way that frankly makes elections disorderly and unreliable and suspicious. And it's radically reduced public trust in elections. And for the last 15 years, we've been suffering through 2 weeks of post-election uncertainty because people aren't just getting their ballots in time or returned in time. And frankly, the denominator of ballots outstanding continues to increase, which when people go to bed at night, they need to know how many ballots are outstanding. They need to know how many ballots are left to be counted, and they don't need to wake up 3 days later and find out there's an additional 150,000 ballots coming in. So it's just frankly a radically undermining elections.
It is, and I can tell you, in Florida, third largest state in the country, we know how to do this. We get our ballots in on Election Day. We have results by 9 o'clock. So it can be done, and it absolutely improves voter confidence. Let me also touch on this. There's a lot of discussion about citizenship, in and around today's hearing, but would you elaborate on the other reasons? There are actually a multitude of reasons why somebody may be need to be removed from voter registration rolls, everything from death to moving. Would you elaborate for us on many of the reasons why somebody might need to be removed from a voter roll?
Yeah, you got to have a clean and accurate voter registration list to keep fraud from happening, right? And so that's the whole reason why it was created in the 1800s. And frankly, states, including North Carolina, are not complying with their NVRA obligations. We sued them 4 years ago. We're currently suing California, Oregon, and Illinois. And people need to know that the way you commit fraud and undermine an election is you have a dirty voter registration list. That's step one.
Thank you, Mr. Noble. Mr. Chairman.
Thank you very much, Mr. Chairman. I agree with my colleagues. All American citizens should have the right to vote. I do, however, disagree that the desire to have all Americans being able to vote has been bipartisan in the past. Having been a child during the Jim Crow era, I can assure you that the Make Elections Great Again bill is not Jim Crow. But let's talk about Jim Crow in Virginia. In 1902, the Virginia Constitution was rewritten by Democrats. They didn't take it to the people to vote on it. They just did it assembled in Richmond. And the concept was, everybody will recall, to disenfranchise African Americans. But what people don't recall is it was also to disenfranchise poor, white, Republican voters in the western part of the state, the very part of the state that I now have the great pleasure and proud to represent. It was done to take them out of the voting rolls too, because the Republican populist coalition was challenging the dominant Democrats in the state. And the Democrat Party did that, led by E. Carter Glass of Lynchburg, Virginia. And it would take some time to break that coalition up. And you know what it was, Mr. Chairman? It was the federal government interfering, according to all the Democrat politicians of the time, interfering in the states and telling them you can't continue to run your elections with poll taxes, with complex subjective registration processes, and having, quote unquote, an understanding clause, making sure that people understood what was going on in the election, that broke that up in the mid-60s. And guess what followed that? The election of the first Republican governor since Reconstruction in 1969. I participated in that election, not as a voter, but as somebody working out there in the hustings. Yeah, I was a weird kid. And I remember the debate between the Mountain Valley Republicans and the Democrats who controlled everything and who didn't want blacks, and poor whites from the western part of the state actively participating. So I assure you, Mr. Chairman, your bill is not Jim Crow. I've got to tell you, it was an interesting time to live in, and I'm glad it's passed. And what we want to do is to make sure American citizens can vote. Mr. Noble, from your experience as an attorney, do you believe that our current penalties for election fraud sufficiently deter bad actors?
No, and fraud's been going on for 200 years in American elections, and I submitted in my record 2 written books, one by the former chairman of this committee that documented countless frauds in the 19th century, another book that documented countless frauds in the 20th century. So when you look at fraud, you can't look at it in the terms of last week or last year or 2 years. I mean, it's a competition. People are cheating.
Yeah. So you're saying we should enhance the law?
Yes.
And you think that the Make Elections Great Again will help us do that?
Yes.
I do too. Mr. Noble, in your experience, what have been some of your concerns raised with the practice of allowing third-party operatives to collect and submit ballots to polling centers, i.e. ballot harvesting?
Well, that's why we invented the Australian ballot, so people wouldn't be harassed, and so they would monitor people's votes. People could go in and vote privately in a secure location when they wouldn't be harassed. And so this sort of advent of all-mail balloting and ballot chasing programs or ballot harvesting programs basically returned us to the bad days of old in the 19th century, where poor whites and the few minorities that were allowed to vote were chased and harassed so they could watch their votes. And we invented the Australian ballot so people would stop getting paid to vote, right? And that brought a lot of the protections we enjoy right now.
In my district, that wasn't just paying them with cash. Sometimes it'd be a bottle of whiskey.
Or a club against the head.
Yeah. Yep. You believe the Make Elections Great Again Act will prohibit ballot harvesting nationwide?
Yeah, it'll be a great improvement.
Do you think that makes our system cleaner and more open for American citizens, including African Americans and poor whites in the mountains of Virginia?
Yes, people should be allowed to vote in secure locations away from all the harassment that they might get at home.
Thank you very much, Mr. Chairman. I yield back.
In a recent video, Secretary Benson says states can and must hold the line in defiance of the DOJ's attempt to enforce federal election law. Do you believe Michigan should defy the department's efforts to instill integrity in Michigan's voter laws?
Absolutely not.
Mr. Noble, I'd like to throw this over to you. Can you talk a little bit about what's happening in Michigan and why you think it's so important for us to make sure that these voter integrity laws are held?
Yeah, I mean, the Department of Justice's ability to get those records for, frankly, 30 years has been unquestioned, right? I mean, when we enforce it at DOJ, the DOJ gets it. It's Section 8I of the NVRA. Michigan has, inaccurate voter registration lists. There are certain quirks about it, Michigan, that makes it difficult to enforce it there that I can't go through here. But they have very outdated lists. It's one of several states that do all over the country. I mean, I talked in my testimony about California and other places, so I won't go through that here. But I mean, 21 counties in California removed 11 voters for change of address. I mean, that's not even, it's tough to even take that seriously. So you can extrapolate from that onto Michigan, which is even more defiant than California sometimes. So its roles are very inaccurate, I suspect.
And I think on that note, when I first got to Congress, I come from the state of Oklahoma, where we have very stringent voter ID laws, which were passed by the citizens of Oklahoma back in the 90s. We also have very strict mail-in ballot laws. We are required to have it notarized. And in my state in 2020, a lawsuit was filed to actually throw out that notary requirement. Fortunately, as a former legislator, I was part of the process by which we were actually able to confirm that you had to have some sort of voter ID along with the ballot. Universal mail-in ballot sort of initiative that we've seen in some states is ripe with fraud. When I got to Congress, I had no idea what curing a ballot meant. I had never seen a ballot box until I got to Washington, D.C. These are ways that we are using the system for fraud, and I hope that we will address some of these concerns in this legislation and legislation moving forward. And with that, Mr. Chair, I yield the balance of my time.
The gentlewoman yields back.
Mr. Noble, Judicial Watch has filed lawsuits to compel voter list maintenance, including the removal of eligible voters. Under our bill, the Make Elections Great Again, or H.R. 7300, which I am an original co-sponsor, updates voter list maintenance requirements nationwide, including by allowing removal if a registrant is discovered to be a non-citizen. How does this change of address issue have you seen or argued about in court?
Thank you for the question. So the current NVRA has very limited removal options. We can do it for change of address, death, and a few others, but those are the two big ones. There's been restrictions on the ability to remove people directly for citizenship. And if you recall, in 2024, before the election, there was a big debate that the Supreme Court resolved in Virginia right before Election Day. You know, the MEGA Act takes list maintenance from a periodic reasonable effort requirement to a more specific requirement. And it's frankly not all that different than what the Congress did in response to the Uwakava Act in 2009. If you recall, 2008, military votes needed to go out within a reasonable time, and there were a lot of problems that happened in the 2008 election. And then in 2009, in response to those problems, Congress set a hard deadline for Uwakava ballots to go out in the MOVE Act. And so with this amendment that is being proposed for the MEGA Act, make those changes.
President, I have more questions, but bottom line, it is beneficial to have a uniform baseline standard for voter list maintenance requirements. I'd like to point out a couple things, because with all the pomp and circumstance and all of the things my dear colleagues have said, I went ahead and I do read the New York Times. Some on our side do. I just wanted to read a quote from there. So as as legislators discuss, Article 1, Section 4, this is coming from New York Times, so it's, pretty factual according to my colleagues. Article 1, Section 4 of the Constitution states, that states set the time and places and manner of elections. It also grants Congress the power to make laws about elections. That's what we're talking about today, folks. That's all we're talking about. And to my dear colleagues, some of the other things that I have, and give me just one more second. Some of the letters that have been put in for the record against this legislation, all I ask, the old phrase, judge them not by their words, but by their deeds. Look at the fundings of a lot of the groups that are saying to not support this legislation. So with that, happy to be an original co-sponsor, and Mr. Chairman, I yield back.
The gentleman yields back. The representative from Illinois, Ms. Miller, is recognized for 5 minutes.
Thank you, Chairman, for holding this hearing today, and thank you to our witnesses for being here. House Republicans are leading the charge to restore faith and trust in our elections. Election integrity should be a nonpartisan issue, but sadly, House Democrats have made it clear they have no interest in restoring confidence and ensuring security in our elections. As ABC noted this past weekend, 83% of adults support requiring a photo ID to vote, as do 73% of Democrat voters. And yet, Democrat elected officials oppose voter ID at every turn, and 14 blue-leaning states, including Illinois, have refused to implement this common-sense measure. The House will be voting on an expanded version of the SAVE Act this week, and House administration Republicans, led by Chairman Stile, have introduced the MEGA Act, which builds on the SAVE Act, with additional critical reforms. Mr. Nobile, first, I want to acknowledge and thank you and my Illinois colleague, Congressman Mike Bost, for fighting to secure the right of candidates to challenge state election laws in federal court. As you know, Illinois insists on the controversial practice of counting ballots received after Election Day, and I'm glad that Congressman Bost's challenge to that policy is moving forward on its merits. In regards to a related case, how does Watson versus RNC, currently before the Supreme Court, affect congressional efforts to ensure that ballots are received no later than Election Day?
There's been some, I guess, the Supreme Court will settle the issue under current law if we prevail. Congress can obviously make new law and be more explicit in what it requires if it acts now. But this question, which arose in Bost first and now is in Watson, is what is the original public meaning of the 1845 statutes? What is Election Day?
Well, we're going to look forward to that. When it comes to voter roll maintenance, how do we ensure that states comply with the requirements set by MEGA Act when many are already non-compliant with the current NVRA statute?
Well, I think forced disclosures, which we try to do at Judicial Watch, and then frankly, just follow up with suits. I mean, there's fertile ground and opportunity for us to sue over. Frankly, we shouldn't have to come to that, but obviously lawsuits help. And, you know, when we find when we find a jurisdiction in violation, it's usually not a close case. I mean, they're not sending out confirmation notices. They're not removing people. It's pretty slam dunk. But, you know, the partisanship nature of the question makes it very difficult to get anyone to just settle and resolve the questions.